Yeah. Members, we're getting going. Members of Parliament, support staff, radio listeners, TV viewers, those following this meeting via social media, members of the media, ladies and gentlemen, good afternoon. I welcome you to the continuation of this Central Committee meeting of Parliament, Central Committee meeting number 9 for today, Friday, January 24th. I want to give a special welcome to the Honorable Minister of Justice, Ms. Natalie Tacklin, and her support staff here today. And we have established a quorum of 4 factions. Please stand for a moment of silence. Thank you. I have received notice of absence from the members the Weever, Kotai, Lewis, Irian, and York. I have no notices of lateness, so I ask, are there any other notifications from the floor? That does not appear to be the case, so we can continue with the agenda point for this meeting, namely, discussion with the Minister of Justice on pending matters within the Ministry of Justice. This document is registered under 131 of the parliamentary year 24-25 and is dated October the 7th, 2024. This was a meeting requested by the members of Parliament Roseburg, Brug, and the Weever. As I mentioned, it was on October the 7th that Parliament received this letter, IS 131, from members of Parliament just mentioned, with a request for a Central Committee meeting of Parliament to discuss the above-mentioned agenda point, namely, discussion with the Minister of Justice. The presence of the Minister was also requested, and please note that today's meeting is a continuation of the meeting convened on October 21st of 2024, during which the requestors of this meeting were given the opportunity to elaborate their request. And this was followed by opening remarks by the Minister of Justice, Mr. Lyndon Lewis at the time, after which members of Parliament were given the opportunity to pose questions to the Minister. After a brief adjournment, the then Minister of Justice, Minister Lewis, provided the answer to the questions posed by MP York, and thereafter the meeting was adjourned to allow the Minister time to prepare answers to the remaining questions posed by the members of Parliament. Today, we have the Minister of Justice, Ms. Natalie Tacklin, who has returned to Parliament to provide answers to questions posed by members of Parliament during the meeting, or the first part of this meeting, of October the 21st of last year. So, hence this meeting today. And with that brief introduction to the status of this meeting, I now give the floor to the Minister of Justice, Ms. Tacklin, for any opening remarks she might have and to provide answers to the questions posed by members of Parliament. Minister Tacklin, you have the floor.
Good afternoon, Honourable Chair Lady. Good afternoon, members of Parliament. It's nice to be back again after just a couple days. I think what I wanted to start off by saying is, of course, this meeting was started under my predecessor. And, you know, late yesterday afternoon, we got a list of many of the questions as they were posed. But unfortunately, the way I received the questions, they're not designated by who asked what question. So I just have the list of questions. I also don't know if this is the complete list. So if there are any questions that are missing, please know that it was not done out of any bad mind on my part, and I would be happy to still answer those questions should they come up. So if an MP notices that I missed a question, please, I guess, if there's a moment for clarifications or so, I look to the chair to see if there's an opportunity for that. But then we'll do our best to answer. We've been very busy throughout the yesterday evening and this morning addressing all the questions of the members of Parliament. So I'll just go right into it, because I think in terms of opening remarks with respect to my vision and pending matters in justice, that I've made quite a few statements during the budget debate, and those still stand, and they'll also, I think, inform the questions that we answer now going on. So I'll start with the first question that I have, which is, why are resident permits of partners of St. Martiners still being issued with the condition that they are not allowed to work? Based on the court decision, it was ruled that we cannot put in the residency permit of a partner of a resident of St. Martin, not allowing them to work. And then there was another question asking to indicate where this is shown in the law and whether this was the purview of the minister. So following the court's ruling of November 30th, 2022, the necessary adjustments have been made to the restrictions section on the residence permits. So previously you would see under the conditions, arbeid is toegestaan or arbeid is niet toegestaan or arbeid is vrij toegestaan. We're working on removing that text from the different formats. What I've noticed is sometimes they still slip in, but we're working on those IT issues. However, so the restrictions now have been changed, and essentially what the arbeid is toegestaan, arbeid is niet toegestaan has been removed, and instead there's a text at the bottom indicating that your residency permit does not exempt you from the requirements of the Landsverordening Arbeid Vreemdelingen, which is our labor legislation, so that you, of course, regardless of the fact that you have a residency permit, you are still subject to those conditions as stipulated in that law, because the Minister of Justice, of course, cannot make any statements regarding the employability or the right of anybody to work, as that falls under the purview of the Minister of VSA. Then I have, why does the ministry accept the practice that a suspect who is in detention is automatically transferred into immigration detention on the request of the prosecutor? The prosecutor cannot and or does not have the authority to make the decision to transfer a suspect into immigration detention. If I am wrong, please indicate where in the law this is stated. It is not the public prosecutor that makes the decision of whether or not a person or a suspect is transferred into immigration detention. Immigration-related detention is overseen by the immigration authorities under the auspices of the Minister of Justice, often in conjunction then with judicial oversight. An interview is held with individuals who have been transferred, and their legal status on the island is reviewed and taken into consideration by the Minister of Justice, who then authorizes the detention of this person or the removal of this person from St. Martin. Following question is, why are persons being held in immigration, or where are persons being held in immigration detention? Currently, persons in immigration detention are held at the Foreigner Detention Center. This is in Simpson Bay, and the facility is operated by the Immigration and Border Control Services. Under what policy or law is it allowed to hold someone in immigration detention? I refer to Article 16 in conjunction with Article 19 of the National Ordinance on Admission and Expulsion, the LTU. The LTU provides the Minister of Justice with the authority to detain individuals to facilitate their removal from the country under specific conditions. This authority is exercised when the individual does not meet the requirements to legally reside in the country and is subject to expulsion procedures. Detention may be applied when there are grounds to believe that the individual, 1, poses a risk to public order, public peace, safety, or moral standards, or 2, that person may attempt to evade the removal process, such as by absconding or failing to cooperate with immigration authorities. The LTU grants the minister discretionary powers to make this determination, allowing for detention without the need for a formal judicial order. However, these powers must be exercised within the bounds of the law, ensuring that the decision is reasonable, proportional, and necessary for the enforcement of immigration control and the protection of public order. Who is authorized to do that, and what is the process? As I mentioned, this is stipulated in the LTU, Landsverordening Toelating en Uitzetting, or in English, the National Ordinance on Admission and Expulsion, and it is the Minister of Justice who has the authority to do so. Of course, the minister does have the authority to also have a mandaatregeling. So in that sense, the minister can mandate immigration officers to act on behalf of the minister as well. And while this wasn't the question, there is currently no mandaatregeling in place. So currently, all requests or decisions for such are signed by my personally. Question number 7, why and based on what law is this facility approved to be an immigration detention center? Who approved it and based on what standards? There are no explicit national or international laws on the approval of the immigration detention centers. In other words, the facilities don't have to be certified as such. However, the Law Enforcement Council, de Raad voor de Rechtshandhaving, supervises and inspects the quality and operations of the detention centers in the Caribbean part of the kingdom, also of our immigration detention center. The Raad voor de Rechtshandhaving also assesses the extent to which the recommendations of the European Committee for the Prevention of Torture and Inhuman, Degrading Treatment or Punishment, the CPT, are being followed. In its 2004 report on the treatment of detained immigrants in St. Maarten, the Council was overall rather positive about the Grenshospitium, as we call it, the FDC, Foreigner Detention Center. They mentioned that though they had some critical remarks on the safety measures, the Council, in its own words, and I quote, has a positive image of the Foreigner Detention Center, and that its inspection shows, quote, that the treatment of illegal foreigners during immigration detention by judicial organizations can generally be considered humane, and that the CPT's recommendations have been partially followed. Minister, are you aware of the recent court decision whereby the court said that you are not allowed to ban a person after he or she has been sent back to their country of origin? What did the ministry do with this ruling? I am, in fact, aware of the ruling, and my personal opinion is that the ruling is in line with the principle of legality. From this principle, it follows that, that government powers are limited by law, and that every action needs to be also anchored in the basis of the law. So while the legal ban might align with the Richtlijnen, which is a policy document, it isn't in the law itself, which therefore makes it illegal in this sense. So in that, I wanted to then explain that for binding powers or authorities, which we say in Dutch, bindende bevoegdheden, these can't be attributed to policy. They need an anchor in a landsverordening, and which is the point here. So the ongewenst verklaring has to be explicitly regulated by law, specifically in the LTU. We see that, for example, this is done in the BES Islands, and in their legislation, there's Article 16D and E, which explicitly regulates the revocation of declaring a person to be an undesirable alien and attaching legal consequences to such. That being said, in the future, we will have to amend the LTU if we wish to implement this ongewenste verklaring. Sorry, when we speak in Dutch, or when we speak in legal terms, my brain sometimes has trouble with the Dutch and English translations. The next questions I have are pertaining to the prison. Suspects who are in pre-detention at the police station are being released by the prosecutor's office due to lack of space. Everyday suspects are being released. It is only a few that are being transferred to Point Blanche. After sentencing, the inmates sit 2/3 of their time. The minister and/or the ministry are in charge of deciding on the release after sentencing. The minister gets advice from the probation officer, prison, and CCR for the advising part of the release. There is no actual role of the prosecutor. Minister, can you tell me if it is correct that the prosecutor has a huge say in who gets released after sentencing? If so, why and based on what law? With regard to preliminary detention, voorlopige hechtenis, the OM makes a case-by-case consideration based on, among others, the severity of the crime, the impact on the interest of the victims of a case, the impact of the crime overall, and the risks that a suspect poses to the community, and also, of course, the available cell capacity. Pursuant to Article 131, Paragraph 2 of the Criminal Code, detainees sentenced to more than 1 year may qualify for a conditional release after having served 2/3 of their sentence. By law, the Central Probation Board, the CCR, issues the final advice, but it is the Minister of Justice who decides whether the convicted person will be conditionally released and also determines the specific conditions attached to such release. Advice and decisions on conditional release are based on the Criminal Code, the conditional release policy, and case law. Based on case law, appeal court decisions, the process for early release needs to be started at least 2 months prior to the early release date. This never happens. Why is there a backlog on the advices from the CCR? Are they still functioning? How many members does the CCR have? What is the time frame they need to advise? What is the reason inmates don't get their decisions on early release on time? The Early Conditional Release Working Group, de vervroegde voorwaardelijke invrijheidstelling, discusses and determines whether a prisoner qualifies for early conditional release due to lack of cell capacity. The Probation/Parole Office, SJIS, the Judicial Affairs Department within the Ministry of Justice, and the prison, as well as the OM, which is responsible for the execution of criminal court decisions, are represented in the working group. And they jointly determine whether a person is eligible for early conditional release. As soon as it's determined who is eligible for early conditional release, both the prison and the probation office set up their report and their advice, which is then sent to the CCR for final advice to the minister. The CCR should by law consist of at least 3 members, including the chairperson and a deputy who are appointed by the Minister of Justice, and also a secretary who is to be provided from the Ministry of Justice. I can report that the CCR is fully functional and consists at the moment of 4 members and a secretary. I also make reference to this Wednesday's newspaper article on the CCR and also the publication in the National Gazette last week, which outlined some recent appointments that I did to the CCR to ensure that the board was, again, complete and that they can function adequately. The CCR requires on average 2 weeks to issue an advice once all necessary documentation regarding the prisoner eligible for conditional release has been received. This may be longer if the prisoner must be heard as part of the process. According to the CCR, there's no backlog in the issuing of advice on conditional or early conditional release cases. Delays in decision-making are exceptional, and when they occur, they are generally caused by delays in initiating the conditional release procedure. The early conditional release policy document will also be shared with Parliament and details the process in detail. Then I'll just bundle questions 12 and 13 and take them together. Or 12 and 13 I have on my paper here, but the former minister published a so-called early release and ankle bracelet policy. In this policy for early release, due to lack of cell space under ankle bracelet or other conditions, it is at the discretion of the minister, it states. Verbally, it is mentioned that they have an extra 6-month deduction on their time if there is a situation they need the cell. Shouldn't there be a transparent policy that applies for all? Because now how do you decide, minister, who gets released before their time? And then to tack on to that, minister, now that we have a serious problem with cell capacity and suspects are being released after a couple days from police custody and adults are being detained at MLC, how come we have not introduced the old policy on early release again, which the former minister Duncan had cancelled for no reasons? Aruba and the BES and Curaçao all have this policy. Where is the policy for St. Martin? As far as I know, the so-called early release and ankle bracelet policy was first implemented by the first Minister of Justice of this country, Mr. Roland Duncan. And this was done under the ministerial regulation on electronic monitoring at the time. The regulation provided for the possibility that a prisoner could, by way of leave the prison 1 to 6 months prior to their conditional release, on the condition that they had to be placed under electronic monitoring. In practice, the prisoner effectively receives a reduction of 1 to 6 months on their prison sentence through the leave under electronic monitoring. This regulation was revoked in 2015 due to the coming into effect of our new Wetboek van Strafrecht, Penal Code. It follows from the conditional release arrangement in the Penal Code itself that every convicted individual, with exception of those serving short sentences, must serve 2/3 of their sentence unless this period is reduced pursuant to Article 137 due to a lack of available cell capacity. Upon entry into force of the new Penal Code, any informal reductions in the execution of the sentence, such as those regulated in the regulation on electronic monitoring, had to be abolished. So in here, when I saw the question, it was abolished for no reason. There was a reason, and it was namely that it was in contravention of the new Penal Code. For cases involving cell shortages, Article 137 of the Penal Code allows only early conditional release with or without electronic monitoring for those closest to their natural release dates or for those who have served significant portions of their sentences. The decision to grant early conditional release falls under the authority of the Minister of Justice after having received advice of the Prison Director, Probation Office, and the CCR, or the Court of Guardianship in the case of juveniles. Minister, during the budget debate, and I'm guessing this was a previous budget debate because this question was asked in October, you said that the release of inmates depends on various persons. You mentioned the governor, prosecutor, and even lawyers. Can you please explain what you mean? As mentioned, the release of inmates is clearly mentioned in the law. Lawyers have no say at all in which inmates get to be released. Please clarify. To clarify, the release of inmates involves input from various parties as outlined by the law. For instance, in the case of a pardon, gratie, the request is addressed to the governor and subsequently forwarded to the Ministry of Justice for review. During this process, the court and the prosecutor's office provide mandatory advisory opinions. In matters of conditional or early release, the process requires advice from several key stakeholders, including the prison director, the probation office, and the CCR. Based on these advisory opinions, the Minister of Justice makes an informed decision regarding the inmate's eligibility for release. Lawyers, while not directly involved in decision-making, can play an important role in advocating for their clients at various stages of the inmate's case. What I've heard, Minister, is that once there is a problem with cell capacity at your ministry, your ministry looks at the percentage of the time inmates sat already. The person who has the highest percentage can come out before their time. How is this percentage being calculated? Do you calculate the percentage from the time they got sentenced, or do you calculate the percentage from the time they actually have to sit? So sentence minus 1/3. Is this also written in a policy or a verbal agreement? It follows from the law, not from policy, that prisoners are recommended for early conditional release based on the reasoning that they have, relative to other detainees, served the largest part, highest percentage of their prison sentence, minus 1/3. For the sake of clarity, I would like to refer to the explanatory memorandum of the Penal Code, where it is stated as an example that every prisoner in principle serves 66.6% of their sentence, except for those serving short sentences. If there is a shortage of prison capacity, this percentage is adjusted downward, for example, to 64 or perhaps even 60%. Assuming the legislation is often a codification of policy, it is reasonable to conclude that the legislator intended for an additional sentence reduction of no more than 6%, that is, beyond the standard 33% reduction. Minister, what is the status for inmates to get medical help? Currently, a few inmates need urgent medical attention and are still waiting on the ministry to take a decision. Based on recent court cases, the prosecutor's office is stating that the final decision is still being made by the minister. Is this true? And if not, please clarify. All inmates have access to comprehensive medical assistance whenever necessary. The prison has established a partnership with a qualified medical doctor who is on call to provide healthcare services and treatment for any medical issues that arise. This includes regular checkups, emergency care, and ongoing health management. As minister, I maintain a policy of non-intervention in the day-to-day operations of medical care within the facility, allowing healthcare professionals to make decisions regarding inmate health based on their expertise and the special needs of that specific individual. Based on the law, an inmate needs to work once they receive their sentence. What is the status of this? Why are inmates who have received a long prison sentence still not working? What is the ministry's vision on this? This issue is being addressed. I recognize the importance of a well-structured work program for prisoners as part of their rehabilitation and reintegration process. However, due to the deplorable state of the prison and, of course, our budget, and also the limited facilities available, it creates serious challenges to provide labor opportunities for inmates. Efforts are underway to explore solutions, including infrastructure improvements and collaboration with relevant stakeholders, to create opportunities for meaningful work within the constraints of the current situation. What is the minister's vision on inmates working outside of the prison? I strongly support reintegration and believe in giving inmates meaningful opportunities during their incarceration. Allowing inmates to work outside the prison can be an important step toward rehabilitation, provided it is done safely and with clear safeguards in place. Such programs must serve a constructive purpose, equipping inmates with skills and experience that prepare them for life after prison. However, this work should never feel like an extra punishment to the inmates, but rather a chance for personal growth and for a contribution to society. It's essential to explore opportunities where these efforts align with both rehabilitation goals and public safety. I envision a prison that isn't simply a warehouse for individuals, but actively works to rehabilitate them and prepare them for life beyond incarceration. How does the ministry guarantee that the detention of detainees aligns with human rights standards? And how is the ministry ensuring that there is no breach with Article 3 of the ECHR? The ministry is committed to ensuring that detention conditions meet human rights standards, including compliance with Article 3 of the ECHR. Significant improvements have been made to the Point Blanche prison to enhance living conditions and prevent inhuman or degrading treatment. These include refurbishing recreational rooms, establishing a new music room, gym, barbershop, and common areas, as well as repainting all inner walls and exercise yards. In addition to funds earmarked in the national budget for repair work and maintenance, sufficient financial resources have also been made available by the Ministry of B.Z.K. to support the prison's efforts to address the issues identified by the CPT. The Dutch custodial agency, DAE, has signed a service agreement to support Point Blanche, and the Ministry of B.Z.K. has granted a contribution to the NRPB for the support of the Ministry of Justice of St. Martin for up to 927,000 euros to provide technical assistance to implement improvements to and within the current facility. The NRPB has been tasked with the recruitment of a program manager and team to implement the needed material and organizational changes. The law allows for the possibility of granting a pardon under Article 611 of the Code of Criminal Procedure. Why has it been decided to provide a sentence suspension, 116 criminal law book, for the inmate that I understood is terminally ill and not grant a pardon so that he can enjoy the remaining time he still has alive? Please be informed that the inmate in question has been sentenced irrevocably to a 14-year prison sentence in 2024. Due to medical circumstances, this inmate received a suspension of his sentence, schorsing, earlier in 2024 and has been flown abroad to receive medical treatment. It is also important to note that on August 28, 2024, the inmate, through his lawyer, had also submitted a request for pardon, gratie, to the governor. This request was handled in accordance with Article 118 of the Constitution and reviewed with the advice of both the court and the OM. Based on these considerations, the request for pardon was denied by national decree dated 17th of October 2024. The court and the court and the public prosecutor's office were of the opinion that granting a pardon to the prisoner in this case was not the appropriate modality to facilitate his release. The circumstances presented on behalf of the prisoner at the time were deemed insufficient to qualify for a pardon. This is why instead a schorsing was chosen. There are currently still inmates in the Netherlands. How is the ministry ensuring that they are released on time? As I understood, there is currently an inmate that had to be released since the beginning of October, but is still incarcerated. Could you give clarification in regard to this? The inmate in question, or at least the one that we assume it to be, is a prisoner from St. Martin who has been incarcerated in the Netherlands since November 2017. The CCR conducted a digital hearing with the inmate to provide a thorough advisory opinion to the Minister of Justice regarding his potential conditional release. During his detention, the inmate received multiple disciplinary reports, including positive drug tests and inappropriate behavior toward prison staff. Both the CCR and the prison director issued negative recommendations regarding his conditional release. Based on these recommendations, the inmate's release was postponed for 1 year in line with the established procedures. How is the ministry ensuring that inmates that need to be transported to other islands based on the onderlinge regeling, because of, for example, medical reasons, are transported in a timely manner? as I know of situations where an inmate is currently waiting 2 years for transport while he is not medically fit to remain in the Point Blanche prison. Regarding this specific case, it's important to note that an OR-day medical request has been submitted, and the OM who has to execute this request is currently awaiting a response. Therefore, the inmate in question is not awaiting transport at this time, as no decision has yet been made on the request. The ministry continues to monitor the situation closely to ensure that all procedures are followed and that the inmate's medical needs are addressed appropriately. We're also hoping that we can resolve this issue within the next couple of weeks. There are a lot of moving parts in requests like this, as they require approvals from Bonaire, from the Netherlands, and we're working diligently to ensure that this inmate can receive the necessary care. Who is in charge of the early release of inmates once they have been irrevocably sentenced? The early release process for inmates who have been irrevocably sentenced begins at the prison, where the calculation of the inmate's eligibility at 2/3 of their sentence is made. The prison initiates the process by preparing a pre-selection report, which is then forwarded to the probation department for assessment. The probation department conducts an interview with the inmate and compiles a detailed report, including recommendations on specific conditions the inmate must adhere to upon release, such as mandatory reporting at the probation department, a location restriction/ban, and electronic monitoring. The prison and probation reports are submitted to the Ministry of Justice. The ministry forwards the entire case file to the CCR, which reviews the reports and provides an advisory opinion to the Minister of Justice. The final decision regarding early release is made by the minister. It is therefore the Minister of Justice who in the end decides whether the convicted person will be conditionally released, and also determines the specific conditions attached to such release. Advice and decisions on conditional release are based on the Criminal Code, the conditional release policy, and case law. I understood that it takes very long for inmates to receive their release date after being sentenced, and when they do, it's inaccurate. Can the ministry look into this? I have to mention that no such issues have been reported to me at this time. However, I understand the importance of ensuring that inmates receive accurate and timely information regarding their release dates, and I will look into this matter to verify the situation. And as I said, I don't know who asked the question, but I thank the MP for the question and for bringing it to my attention. Is there any consideration being given to the introduction of a weekend verlof for inmates close to the ending of their prison sentence, similar to what was done in the Netherlands? Weekend leave is a rehabilitative initiative that offers inmates a gradual and structured transition back into society. During weekend leave, inmates would have the opportunity to reconnect with families, social networks, and potential employers, all of which are critical to ensuring a smooth transition back into the community and reducing recidivism. The concept of weekend verlof, I've been told, has been discussed in St. Maarten on several occasions with prison management in 2023 and 2024, including with the use of electronic monitoring to ensure public safety and the integrity of the program. However, while the law currently allows for a general leave, a specific weekend verlof requires a legislative amendment. In addition, we of course also have to look at our human resource constraints at the moment when it comes to this. When will the ministry make use of the option for inmates to work outside the prison? The law provides that option. It's a win-win situation. I touched on this in a question above, but I also wanted to add that the ministry recognizes the benefits of allowing inmates to work outside the prison, and I agree that it's a win-win situation, contributing to the rehabilitation and reintegration while providing value to the community. However, implementing such a program requires careful consideration of safety and security concerns, as well as, and there we have it again, sufficient manpower to oversee and manage the process effectively. Is there any outcome of the investigation in regard to the attack on the inmate in the isolation cell? If so, can the outcome be shared with Parliament, if needed, confidentially? The investigation is still ongoing under the authority and supervision of the Public Prosecutor's Office. At this time, I do not have any additional information to share. If and when further information becomes available, this can be provided to Parliament in accordance with the appropriate procedures, including confidentiality, if necessary. In a news article on June 4th, 2024, the then minister reported to have said, "The attack was made possible due to corruption within the prison system. Based on what kind of evidence was this statement made? Had this been confirmed? Have disciplinary actions been taken?" I cannot comment on statements made by the previous minister, as I was not involved in the circumstances or context in which they were made. However, this matter is being followed up on. What is the status of the sexual assault cases at the prison? How is this being tackled? This case has been dropped. Is there sufficient staffing to manage the prison effectively and ensure the safety of inmates and staff? If not, what is the short-term solution to solve this matter? How will the ministry ensure that similar incidents/attacks in a solitary confinement cell do not occur in the future? There are serious challenges within the prison system due to staff shortages, long working hours, and a high rate of absenteeism due to illness. Budgetary adjustments are needed in order to tackle the present staff shortage at the prison. I deeply regret any incident that compromises the safety of inmates and take such matters very seriously. While every effort is made to ensure the safety and security of all prisoners, it is important to acknowledge that no one can guarantee absolute safety at all times. The current challenges within the prison system, including staff shortages and a high sickness rate, further complicate our ability to maintain optimal safety and security standards. The Ministry of Justice, in collaboration with KPSM, that is not meant for here. Yep. We're working on it. Sorry, we had, the system was glitching a little bit, so I got a different question. But all in all, we're looking into it. I'm still trying to get more information on what transpired in terms of the attack on the inmate, and I've requested this from the public prosecutor to be briefed. What concrete steps have you taken to address the material shortages within the police force? This so the police can execute their job accordingly. How will this be tackled in the short term? This matter has the attention of all within the Ministry of Justice. As we are faced with the reality of a decreased budget, we are discussing ways to make efficient and effective use of our limited resources. And addressing these realities is crucial, and budgetary parameters must evolve to tackle these shortfalls. Seeing that the crime fund is being used without a policy plan in the budget meeting, I would suggest that the funds be divided between an X percentage used for justice and an X percentage used for projects, such as those being done in Curaçao. What is the ministry's position on this? When will this be implemented? As I mentioned during the budget debate, while unfortunately we weren't able to create a proper policy plan in time for it to be presented with the budget 2025, I made the commitment to Parliament that detailed proposals would be submitted during Q1 of 2025. In developing these policy plans, I want to mention that the allocation and use of crime fund resources will be handled with utmost care. This is particularly important in light of the critical remarks previously made by the General Audit Chamber and the Council for Law Enforcement, which highlighted areas of concern regarding the fund's management. Discussions have already commenced with the Minister of Education, Culture, Youth and Sports to collaborate on crime prevention initiatives within the schools, and I also intend to allocate funding towards initiatives that address human trafficking with the goal of improving our Tier 3 status within 2025. Then, given the fact that the police corps has already been reduced by 50%, what measures have been implemented to ensure that justice personnel remain motivated despite limited resources and unresolved working conditions? Since taking office, I've prioritized the well-being and motivation of justice personnel despite the challenges of limited resources and unresolved working conditions. I've held meet and greet sessions to foster open communication, allowing employees to voice their immediate concerns and share their suggestions. This commitment to transparency and collaboration is ongoing, and I still have plans to, early in this year, have a town hall to address the issue around the Landsbesluiten. To further support our personnel, I've ensured open lines of communication with my cabinet and myself so that employees can raise concerns promptly and have them addressed effectively. Additionally, the ministry is actively supporting partnerships, such as the collaboration between KPSM and the Mental Health Foundation, to provide psychological assistance to officers and staff, recognizing the importance of mental well-being in maintaining motivation and performance. My overarching goal is to create a workplace culture where employees feel valued, respected, and empowered to perform their duties effectively. The strength of this ministry lies in its people, and I remain committed to ensuring that they are supported and treated equitably at all levels. What is the short-term plan to bring the number of officers to a higher capacity? KPSM has recently started a new class of 7 BPO students. While this is a positive step, we also acknowledge that more needs to be done to increase capacity effectively. To support this, the ministry is advocating for budgetary adjustments to prioritize funding for critical areas, including human resource needs across the justice chain institutions. A key focus is the implementation of KPSM's growth plan, which outlines the personnel, training, and operational resources required to strengthen law enforcement capabilities. Adequate funding for this plan is essential to address capacity challenges in both the short and long term, ensuring that KPSM is equipped to meet the increasing demands of public safety. What is the current status of the Landsrecherche, given that there is no head appointed? The status of the Landsrecherche remains under review. Steps are being taken with a focus on maintaining the integrity, effectiveness, and operational continuity of the department. Decisions made concerning the previous acting head have been re-evaluated, and I'm in the process of reversing any decisions that were made without a legally sound basis. Regarding the position of a permanent head of the Landsrecherche, I'm actively working with the PG to ensure that this role is filled in the best interest of the organization and in full compliance with the law. As stipulated by the law, the head of the Landsrecherche is appointed by the Minister of Justice based on a nomination by the PG. This process is being carefully followed to ensure that the proper functioning and the integrity of the organization. On what timeline will the position be filled? What is the process? I actually have a meeting this Monday with the PG to discuss this exact process and how we will proceed. In the meantime, previous decisions have been reversed. Is the person that was fulfilling the position for years being considered for this position? The process to appoint a new head is being handled with great care and in full compliance with the applicable laws and regulations. As required, this decision will be made in consultation with the PG and based on the best interests of the organizations. While I cannot discuss specific individuals or potential candidates at this stage, I can assure you that the selection process is being conducted in a fair, transparent, and objective manner, prioritizing the expertise and leadership qualities needed to strengthen the Landsrecherche. How does the minister assess the effectiveness of current measures against rising crime, and what additional actions are being considered to curb this growth? I'm holding constant consultation with the chief of police, and we're also discussing these matters within the Driehoek to see how measures taken or whether they are effective. I proposed the Community Safety Project in 2004, Seeing the Rise in Crime. This project can be executed via the Crime Fund. Seeing that the funds of the Crime Fund are being used without a policy plan, can this project also be put on the priority list to be executed, given the alarming situation in the rise of crime? The document was recently received last week, and it is being reviewed and taken into consideration in drafting the policy plans. What are the ministry's plans to collaborate with other ministries and social organizations to address the root causes of crime, such as poverty, unemployment, and lack of opportunities for youth? I'm in ongoing discussions with my colleague ministers of ECYS and VSA to discuss how we can work interministerially to address these matters. How is the ministry planning to tackle the rise in crime, especially in light of a reduced budget? Are there plans to reassess priorities to seek additional funding through other channels? If so, how? The Ministry of Justice, in collaboration with KPSM, is implementing immediate measures to address the rising criminal activities, particularly violent crimes such as shootings and robberies. KPSM has developed a strategic plan centered on the hotspot, hotshot, and hot times approach. This strategy focuses on intelligence-driven operations, including targeted actions, enhanced surveillance, traffic controls, and preventive weapon control measures to deter criminal activities and apprehend suspects. In the coming weeks, the public can expect increased police visibility and surveillance in high-risk areas. You may have noticed it happening already. The heightened presence not only acts as a deterrent, but also serves to reassure the community of ongoing efforts to address safety concerns. However, and this comes back to the question that was posed just above, crime is a multifaceted issue that extends beyond the justice sector. Tackling the root causes of crime activity requires a collaborative societal response. This includes an interministerial approach that addresses underlying issues such as education, unemployment, and social development. To support KPSM in executing its strategies effectively, the Ministry is committed to ensuring the full implementation of KPSM's plan of approach and growth plan. These plans, which are subject to regular audits by the Progress Committee, the Voortgangscommissie Plannen van Aanpak, provide a framework for accountability and sustainable progress in crime prevention and enforcement. What specific measures have been taken or being considered by chain partners such as the Coast Guard and Customs to effectively combat the illegal importation of weapons by sea and air? Strengthening of cooperation between law enforcement agencies is being explored to enhance coordination and effectiveness in combating crime. How is cooperation between the police, Coast Guard, Customs, and other relevant agencies being improved to create a unified chain approach in the fight against crime? Currently, multidisciplinary teams are operational at the airport and focus on key areas such as human trafficking, human smuggling, and drug-related crimes. These teams work under the authority of the Public Prosecutor's Office, which leads all criminal investigations. How will the preventive role of community police officers be further strengthened and supported within the broader chain approach? The preventive role of community police officers, or CPOs, will be further strengthened and supported within the broader chain approach through a combination of targeted strategies and interministerial collaboration. CPOs are pivotal as the eyes and ears within communities, serving as the first point of contact for residents and gathering valuable information that informs investigations and strategic plans to combat crime. To enhance their preventive role, CPOs will focus on providing tailored prevention advice through information sessions with communities, addressing specific crime trends and vulnerabilities in each neighborhood. Their strategies will be intelligence-driven, ensuring that their efforts align with the unique needs and challenges of the areas they serve. This localized approach not only addresses immediate concerns, but also fosters trust and collaboration between law enforcement and the public. Furthermore, the Ministry of Justice recognizes that crime prevention requires more than just law enforcement. Social and economic issues that contribute to criminal behavior must also be addressed. Strengthening the role of the CPOs will therefore involve working closely with other ministries and stakeholders to ensure a comprehensive chain approach. This includes addressing root causes of crime, such as poverty, education gaps, and unemployment, while creating opportunities for positive community engagement. Did the ministry look at the community safety project that I submitted at the beginning of July 2024? When can this be implemented, seeing the urgent need for such? This document was just provided to my cabinet in any case, so we will be reviewing it. Are there short-term options to improve border control, for instance, through technological advancements or intensified collaboration with neighboring countries? The ministry has a comprehensive plan to strengthen border control, recognizing the unique challenges posed by our open borders. Key initiatives include the country package H11 through a subsidy assistance from the Kingdom of the Netherlands under country package measure H11. Sint Maarten is developing a comprehensive plan of approach to enhance border patrol. This initiative is being implemented across all the countries in the Dutch Caribbean. Further to that, the protocol on border security signed by all ministers of justice in the kingdom underscores the collective commitment to strengthening border management. There are also joint initiatives, including the execution of the Franco-Dutch Treaty at Princess Juliana International Airport, joint patrols in the Simpson Bay Lagoon, and operations coordinated from the Cole Bay facility targeting cross-border and undermining crime. With respect to intelligence and technology, the Immigration and Border Protection Service has established the IRC, the Intelligence Research Center, to gather and share intelligence across the justice and migration chains. The IRC forms part of the Intelligence Center St. Martin, which pools intelligence from all border-related entities. There's also a dedicated intelligence center which will integrate border intelligence, enhancing coordination and response capabilities. The ministry has also procured new processing systems to support and modernize border operations. With respect to Dutch-French cooperation, a treaty for law enforcement with the French authorities enables cross-border intelligence, sharing, enforcement, and investigations. Additionally, a draft operational protocol is under development to facilitate joint maritime controls with our French counterparts. What is the reason there is currently no police doctor available, and how will this issue be addressed in the short term? This matter was actually brought to my attention by the chief in our last driehoek 2 weeks ago, and we will continue discussions on this topic on Tuesday in our next driehoek. And it does have my full attention, and it will be handled with the urgency and priority that it deserves. What is the current budget for victim support services allocated to material assistance for victims? The current budget is 450,000 guilders to VSS. What does the support provided by victim support services currently consist of? An assessment of clients' needs and client consultation, casework in following up with performing tasks to get the client's needs met between stakeholders, writing of important documents needed by institutions, emotional support, case management. They act as a liaison with police and victims. They provide mental health support with their life coach and referrals to mental health service providers when the issues are beyond their scope. In addition, they provide community awareness and education in victimization. This is sexual assault, domestic violence, human trafficking. And soon they will be training the police in domestic violence with their partners at KPSM and the prosecutor's office. VSS also consults with the police on some cases where victims need support to build cases against their assailant. Is there currently a budget available for legal, psychological, and psychiatric supports for victims? Victim support services does not provide psychological and psychiatric support, but they transfer clients to MHF and private practice practitioners. VSS does provide mental health support through the life coach, who supports clients right away, and if issues are beyond their capacity, they are referred. VSS provides mental and emotional health support while waiting to be seen. Only clients that have S.D.V. can really access the care of MHF and private practice practitioners. However, there is a budget to cover costs. What specific documentation is required for individuals to retrieve impounded scooters from the police, and how is this process currently being handled? As I understood, that this isn't clear to a lot of people in the community, and there seems to be a lot of back and forth. The process for retrieving impounded scooters has been outlined by KPSM and is regularly communicated through their social media platforms and directly at the station when inquiries are made. However, we understand that there may still be some confusion, and I would like to clarify the requirements to ensure that the process is clear to everyone. To retrieve an impounded scooter, individuals must provide the following information: proof of ownership, documents demonstrating that the individual is the rightful owner of the scooter, such as a purchase receipt or a registration certificate. 2, valid driver's license, category A. The individual must have a driver's license permitting them to operate said scooter or motorbike. Number 3, an inspection card, proof that the vehicle has passed inspection. Number 4, valid insurance. The insurance must be current and in the owner's name. 5, road tax payment and proof that the road tax has been paid for the vehicle, and lastly, a crash helmet. A helmet must be brought at the time of retrieval. In cases where the person retrieving the scooter is not the registered owner, they must provide an authorization letter from the owner along with copies of the owner's identification and supporting documents. It is also important to note that in situations where the scooter or vehicle has been confiscated, the public prosecutor must decide whether the vehicle can be returned to the rightful owner. What is currently being done awareness-wise to tackle domestic violence and child abuse? Is there a specific hotline people can call? With respect to child abuse and neglect cases, concerned persons can report or request advice from the Court of Guardianship. The Central Reporting Center is housed in the Court of Guardianship, and the emergency hotline number is 918, or an email can be sent to report2cog@stmartingov.org. As part of the awareness efforts, activities included radio interviews, workshops for police officers on the intervention's content, and the distribution of informational flyers at the police station and other locations. To raise awareness and address domestic violence and child abuse, several initiatives are ongoing. The JNIS Probation Department, in collaboration with the Prosecutor's Office, developed the Safe Homes Behavioral Intervention Training Program for perpetrators of domestic violence through grants from the R4CR program. Awareness activities included radio interviews, workshops for police officers, and the distribution of informational flyers at key locations. Then I have questions that I've bundled with respect to Is there a new ankle bracelet policy? Can we receive a draft of this policy? At present, there is no specific policy in place for ankle bracelets or electronic monitoring. Establishing such a policy would require the minister to be attributed discretionary authority, which is currently not provided for in the legal framework governing electronic monitoring. Under the Criminal Code, the use of ankle bracelets is limited to their application as a special condition attached to decisions for conditional release or early conditional release. These decisions are strictly governed by the provisions of the Criminal Code, and the minister's authority is limited. Is the current prison capacity being tackled? Yes, through the construction of the new prison. Based on what procedure will someone be entitled to early release / an ankle bracelet based on the conditional release and early conditional release procedure? Yes, my apologies. We've been having technical difficulties with SharePoint where questions keep disappearing. But one of the other questions that I remembered was there and suddenly wasn't in my file. Are the justice workers not aware that they can file an objection against the Landsbesluit they received? I want to say that justice workers are aware of the objection committee and that they can file an objection. It's also stipulated explicitly on the Landsbesluit that they received that it is open to bezwaar en beroep. Then we were also asked how many objections have been filed so far by the justice workers. Thus far, 52 objections have been filed.
Good.
Yeah, thank you. Then think. Oh, now I'm back. All right. Then what projects are currently in place to tackle the youngsters and adults that are currently often falling into the hands of the law, like the top 500 in the Netherlands? The Youth Probation Office has an integral approach to tackling deviant behavior and youth delinquency. All interventions and activities are focused on stimulating the three areas that accumulate the criminogenic factors, who in turn influence behavior: thinking patterns, behavior and skills, daily activities, home situation, and family dynamics. The Youth Probation Office has projects/partnerships with stakeholders and local partners consisting of one or several of the following elements. The K1 Youth Program is a cognitive development program that provides workshops that stimulate critical thinking, better decision-making, self-awareness, and healing. It also helps the participants prepare for adulthood by providing financial literacy classes, job application writing, and job interview training. With the help of this program, the Youth Probation Office has successfully been able to change the trajectory of several young offenders. The Youth Probation Office utilizes volunteer organizations to place youth in community service projects that stimulate empathy and care for others. And finally, the Youth Probation Office has a partnership with aggression, social and social skills trainers who use the well-known ART methodology to tackle the lack of impulse control and aggression regulation challenges they suffer from. What kind of rehabilitation and socialization is currently taking place in the prison? What projects are currently ongoing? The Prison Rehabilitation and Training Program, launched by the JNIS Probation Department in collaboration with Prison Management in October 2023, is currently ongoing. Training sessions held on Mondays due to the logistical constraints focus on behavioral intervention, with approximately 6 to 8 detainees participating per session. Despite challenges such as limited facilities, low motivation among inmates, staffing shortages, and operational disruptions, the program continues to address key issues like aggression regulation. Efforts are being made to sustain and expand the program, including exploring innovative methods like virtual training, though these would require additional resources. The next session is scheduled for February and will specifically focus on addressing aggression within the prison population. Recent concerns have been raised regarding the internal transfer of employees within the Ministry of Justice. Specifically, quite some time, there are incidents indicating that certain transfers may be motivated by personal grievances or spite rather than objective or thoughtful decision-making. Could the minister clarify the procedure and criteria used to transfer employees from one department to another within the Ministry of Justice? Additionally, what safeguards are in place to ensure that such transfers are conducted fairly and in the best interest of both in the different departments and its employees? This matter has my full attention, and I've been quite busy looking into personnel files or such transfers or revocations of position or removals from position since taking this seat. These matters are all being reviewed and vetted in line with good governance principles and, of course, the best interest of the ministry. While the function book for the police has already been enacted into law, the function book for the Customs Department remains pending. Could the minister provide an update on the status of the function book for Customs, including the timeline for its finalization and enactment? Additionally, what are the key challenges delaying its implementation, and how does the ministry intend to address these issues to ensure the Customs Department operates within the same legal framework as the police? The function book itself for Customs was approved in December 2021 and enacted in December 2023. Discussions are currently in progress with both the unions and the customs authorities to address various concerns and seek mutually beneficial resolutions. I will keep Parliament informed and provide a comprehensive update as soon as more information becomes available. The dismissal of the acting head of the National Detectives has raised concerns, particularly as this key position remains vacant. It has been mentioned that an internal investigation is underway regarding the former acting head. Could the minister provide an update on the status of this investigation? Additionally, what steps are being taken to ensure that this critical leadership role within the National Detectives is filled promptly and in a manner that upholds the integrity and effectiveness of the department? I can confirm that while decisions were made regarding the acting head of the National Detectives pending investigations, that it has come to light that these investigations were never actually conducted. As previously mentioned, I will be engaging with the PG to address this issue and ensure that permanent leadership is appointed to this key position as soon as possible. This process will be carried out in full compliance with the applicable laws and regulations, with the aim of strengthening the integrity and effectiveness of the National Detectives. The appointment of a qualified and capable leader remains a top priority to ensure the department can fulfill its critical role within the justice system. There are growing concerns about the status of the national decrees for the remaining justice employees, as delays in finalizing these decrees are reportedly affecting staff morale. It has been brought to attention that some justice workers are considering resigning and seeking employment in neighboring islands due to unfulfilled promises. Can the minister provide an update on the progress of these national decrees and outline what measures are being taken to ensure that these commitments are honored in order to retain valuable personnel within the ministry? The placement process is complex and requires careful attention to detail, which can make it very time-consuming. That said, we've made significant progress so far, and I'm committed to ensuring that the momentum continues. Our aim is to have all outstanding LBAs for active employees signed by the end of 2025. However, I want to be realistic and acknowledge that achieving this goal will require continued focus and diligence. Challenges may arise, but we are addressing them as they come to ensure the process moves forward diligently. While the process may take time, I assure you that this remains a top priority, and we are working proactively to meet the expectations of our employees. I'm also in constant discussion with all relevant stakeholders to see how we can take steps to improve the efficiency of the process. We can report that out of the 530 employees scheduled for formal placement as of January 1st, 2023, 290 LBAs have been formalized, including the most recent batch 12, which was signed by my person in December. Although progress has been slower than desired by the personnel, achieving over 50% of the phase's progress is still a positive outcome. An update on batch 13. This is currently with the financial controllers for validation, and based on their findings, possible corrections may be required. Then these will go back to the controllers for revalidation, and then to FBBB, which is finance, after which it will then come to the cabinet for review and to prepare to present to His Excellency the Governor. That brings me to the end of the questions that I had. Again, if anything was missed, not done on purpose on our end, but I'm still happy to answer those questions as they come up. Thank you.
Thank you, Minister Natalie Tacklin, and for the answers provided. I will now give the opportunity to the members of Parliament who firstly have any questions that have not been answered, and then also the opportunity if any new/additional questions are to be posed. So according to the indications, I firstly have MP La Cruz. MP La Cruz, you have the floor.
A blessed afternoon, Madam Chair Lady. Refer to the Minister and her support staff, those in the Tribune, my fellow colleagues here in Parliament, those watching on all social media platforms. Madam Chair Lady, through you to the Honorable Minister of Justice. I'd first like to give her some advice on the situation that she has found herself in first, that she was not part of the meeting, the first meeting, but like what I did, for example, I asked our faction staff to go back and look at the video and write down the questions, so we made sure that we didn't miss any. So that would be my advice for any upcoming situations like that, because then it seems extremely disappointing that the minister is not prepared. And I know that's not the Minister of Justice. So I'd like to start with that. Madam Chair Lady, I'm going to go back to the some of the answers that I received from the minister. Then I have something else that I'd like to bring up, but I understood we have a second round, so I'll do those in the second round. Then the situation with the detainees, the immigration detainees in the Simpson Bay. I'd like to know if the minister has ever visited that facility herself, and if she saw all the mold in that building. So I know definitely according to standards, that would not be acceptable. So that is something that I'd like the minister to actually look into. Then another question concerning enough health care at the House of Detention. The minister stated that she has a hands-off policy. She lets everyone, run their own affairs. But I do believe, through you, Madam Chair Lady, to the minister, that once she hears the members of Parliament asking questions concerning a specific situation, that it literally means that we know something that maybe she doesn't, and she should look into it. So definitely this would not be something that I would say should be a hands-off policy. We have gotten enough complaints from inmates, even in our meeting there, that they were not, or they have the feeling that they're not being taken serious when it comes to illness. Then, to you, Madam Chair Lady, to the minister, what exactly is the difference between a pardon and sourcing? Okay, if the minister could explain that a little more, I would love that. Then I heard all the stipulations concerning the scooter riders, but I have another question. Are these stipulations also in place when the scooters are purchased? So is anyone taking a look at the businesses that are selling scooters? Are they being sold to 18 years and up? Do they have an insurance? Do they have a license? And all the above mentioned. Because, Madam Chair Lady, as I understood, that the insurance companies are not insuring scooters anymore. So that is definitely a problem. And that is not a problem only for the justice system, but also a problem for every rider or driver on St. Martin. Then that will be, then yes. Good. My other questions, I'll leave them for round two, because those were new questions concerning other matters. We have a round two. After I leave an answer these, then answer. Okay. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. The next speaker is MP Doran. MP Doran, you have the floor.
Thank you, Madam Chair Lady. Good afternoon to you, my honorable colleagues, the Khalifier, the Honorable Minister, support staff, and a special good afternoon to the people of St. Martin that are tuned in. Madam Chair, I have a few brief clarification and also questions. I would like to start by thanking the Minister for the answers provided thus far. And my first question through you, Madam Chair, is what is being done? Because we've seen over the last couple of years that persons would come here, follow the police, the BPO, the basis police upleading, and after maybe 2 or 3 years, they would then leave the KPSM. We know that we have a serious shortage. I would like to know what is the strategy, if there is any, of the KPSM as to how that is dealt with. Take C6.
Oh, we have. MP Doran, you may continue.
Thank you, Madam Chair. So just to clarify the question, what is being done, let's say, for instance, I know in certain jobs that you would have to, once you follow a course, you'd have to work for the company for 5 or 10 years, whatever is agreed upon. If not, then you would have to pay for the course. What is being done to curb that? Because I find it a bit loss if we invest so much in different candidates and they leave after a short period. If there is anything being done, if not, is it the intention to look into that? Secondly, through you, Madam Chair, I've heard the minister mention in one of the responses with regards to the lance recherche. I want to know if I heard it correctly. Is it so that the PG puts out the vacancy and then gives a binding nomination to the minister to approve, or the PG handles the entire recruitment process and the minister is just there to rubber stamp it? Because that's a bit unclear to me. So I would like to know, is a vacancy then put out by the minister/ministry, or is it totally handled by the Procureur-General? I would like some clarity on that point. And if so, has this always been the case, or is this something new? Lastly, Madam Chair, through you to the minister, this ties into the basically police training. Over the last couple of years, we've seen where certain top vacancies within, in particular, R.S.J would come into play, and then the issue would be that we don't have locals that are qualified for the position. I would like to know through you, Madam Chair, if the minister could indicate if this is her view or if she feels a sort of a system like this can work, whereas in the Netherlands, you allow persons to follow police training based on their level. So for instance, if someone finishes MBO, they then follow a HBO politieopleiding, or if they finish HBO, they then follow a WEO politieopleiding, and then they would go definitely straight into whether as a brigadier, as a two stars or whatever have you, based on the particular study. I think that this option should be introduced. I've had over, I think about 2 years discussing this in different forms or fashion. I've always heard why it can't work, but I do think it's a good idea, and it can also provide opportunities for our people that are that have higher studies to be able to participate and contribute to our judicial system. Because what you would have is that persons that have for instance, a Harvard diploma or even an MBO diploma, and they want to follow a police course, they would all fall in one bracket. And I think that isn't correct. So I would like to know through you, Madam Chair, if there would be an option to allow persons with higher education to follow the same basis upleiding. However, when it comes to the exam, that a different training, whether different books are given in order to accommodate that. I would look forward to the clarity on those points and come back on it. Thank you, Madam Chair, for the opportunity.
Thank you, MP Duran. I now give the floor to MP Roseburg. MP Roseburg, you have the floor.
Thank you, Madam Chair, Secretary General. Blessed afternoon to the Minister of Justice and support staff. Also blessed afternoon to my colleagues here present and to the public in the Tribune and the ones viewing and listening online. I had a lot of questions. Not all of them were answered, but I do understand what was brought forward by the Justice Minister, and some of the questions were also answered during the budget debate, so I'm not going to repeat the questions that were not answered, but I will focus on the ones that I still need an answer to. The first question that I would like to have an answer to, through you, Madam Chair, is who are currently the members of the CCR? Other than that, I now understood that the situation in regards to the interim director of the lance recherche has been revoked. Is there currently any litigation ongoing, or has that also, has a mutual understanding been reached? Why I'm asking that, because it would be unfortunate that Country St. Martin will have unnecessary costs in regards to litigation, especially seeing that the minister just mentioned it has been revoked, some pending investigation that was set that was going to take place. Also in regards to the interim prison director, who also has been removed from his position and has been placed back to R.S.J, I also understood that there was a investigation ongoing in that regard. Can the Cabinet of the Minister of Justice maybe provide some information in regards to that? Has that also been revoked, or is that case still ongoing? Is there any litigation ongoing in that regard? I would like to also know the situation in regards to the interim prison director. Other than that, I listened to what was brought forward in regards to the capacity issue and also in regards to the different articles that have been mentioned. For example, Article 37 of Book 1 of the Criminal Procedure Code. But my question was more focused on capacity-wise, seeing that there is a capacity issue. I understood what was brought forward, that there's a new prison that is being built, but that prison will be finalized in 2028. So my question specifically is, what will be done temporarily? In past questions that I have asked, the ankle bracelet policy has been brought forward several times, but when I ask what is the current capacity, how much ankle bracelets are there available, I was told it was, if I'm not mistaken, around 20, but then I asked how much are currently being used, and I think, but don't hold me to the number, I think it was like a few, 6 or so, or less than that. So is the ministry looking into making use of the full capacity of the 20, and in what time frame will that happen? And not only that, I refer to the policy that was introduced by the Minister Tonkin, if I'm not mistaken. But there was also a policy, and I don't know if it's the same policy, it was referred to as the treintje policy, where depending on the percentage, because I understood the ministry mentioned several percentages, but I do believe, but correct me if I'm wrong, that especially when there is something urgent in regard, such as cell capacity, that the ministry can introduce policies to minimize the cell capacity. So I haven't heard what kind of policy the ministry will be introducing next to what is mentioned in the law, because I do believe that as a Ministry of Justice, you can, through ministeriële beschikking, introduce other policies next to the ankle bracelet policy and next to the early release. And it has been done in the past, so my question is, will that be introduced in the future as well? Because I can remember that, for example, foreigners, if they commit crimes, it can be drug-related, they will be sent home after a few days because of capacity, but locals will not have that because of not being foreign. So I want to know what policy will be put into place, if there will be such a policy. Also, it came to my attention that there are several police officers awaiting being placed in the correct positions, but that there are other police officers that have been placed in several positions already. Is the ministry looking into that? And will that further be looked into? Because it would be unfortunate if there is oneerlijke concurrentie in that sense. I'm not sure if that's the case, but that everybody receive equal treatment in regards to placement in the correct position, and that there's no favoritism in any shape or form. So my question is if the ministry is looking into that matter. Also, other question, I asked that as well, if there is a way in creating incentives. I'm happy to see that there's a new class that has started, but it would be unfortunate if, as we have been seeing in the past and also as we have been seeing during the budget debate, that the capacity of the Justice Ministry is on a low, and we wouldn't want more officers to leave KPSM. So what kind of incentives, if it's maybe an idea to look in creating those incentives. I know, for example, if I look in the neighboring countries and also the Netherlands, if you have, for example, a police officer that you introduce to the corps and that officer finalizes their opleiding, you can get a bonus, you know, so to create certain incentives to up the capacity again. Other than that, even kijken. also in regards to the related crimes to children, maybe it's also an idea to look in establishing a kindertelefoon. I know the number that was referred to, but maybe a kindertelefoon, a child phone where children can call and also discuss the situations that they're dealing with. I do think that those are the most important questions that I currently have in regards to additional questions and or clarity to questions that I have asked.
Thank you. MP Roseburg. MP Myers, you have requested the floor? Yes. MP Myers, you have the floor. I asked that because here it shows, yeah. MP Myers.
Thank you, Madam Chair, and good afternoon to the Honorable Minister and her support staff, to my colleagues in Parliament, and those of you listening via any sort of social media. One of the questions that I have to pose, which is interesting, MP La Cruz mentioned it in regards to, and I don't know if it's true or not, and I would like the Minister to answer in regards to the insurance companies not insuring scooters. I want to know legally how is this possible, because according to the law, for scooters to be on the road, they have to be insured. So this will be, the insurance companies, by doing this, according to me, will be in breach of the law by not providing something that is subscribed by law to the scooter operators. That's one thing. The next thing is, and I just want to state this for the record, I understand that this is a meeting that started and way back in October, when the now Member of Parliament, Lyndon Lewis, was the Honorable Minister of Justice at the time. And we've since subsequently had a budget meeting in which the minister was asked well over 100 questions as it regards to this. And I think it's important to put things in perspective. And why I say that is because only in the next 2 days, the current minister would have been sitting in her function for only 2 months. You know, so I understand the continuation. We'll have to continue the meeting as it is called, but as far as the relevance of it, in my opinion, I think most of the pressing issues were answered during our marathon budget meeting. I just had to say that, Madam Chair.
Thank you, MP Myers. I see that MP Roseburg, let me make sure that I got the right sequence. Yes, we have MP La Vega. Oh yeah, MP La Vega, because you are referred to by seat. So you're seat 13 until we get the names corresponding with the mic, but MP La Vega first. Then we go to MP Roseburg. MP La Vega. Now you are, yes.
Good afternoon, Madam Chair. Good afternoon, my fellow colleague MPs. Good afternoon to the Minister of Justice and support staff. I wanted to know, when it pertains to youth offenders, whether it be in the school, whether it be things they do with criminality, are there programs or plans to create programs where you bring in the parents and you speak with the parents? You know, because a lot of people think that is just the role of the government, but the government can only do so much. You know, I believe in bringing in the parents, speaking to them, and even if it's something like you confiscate scooters from youth riders, I believe that parents should be held accountable as well. But you bring them in, you speak to them, and if there's a situation where the parents or the guardians feel like they can't speak to their youth anymore, sometimes it's overwhelming for them, is there somebody they can call that could possibly come and mentor these youth before it gets to an extreme level? Thank you.
Thank you, MP La Vega. For other speakers I have thus far, I have MP Roseburg and MP Jansen-Webster. I ask and also MP La Cruz, I ask the indulgence of all members, and also piggybacking on what MP Myers indicated, but I would like to, I hope we can maybe close the meeting and whatever answers still to come to members of parliament. But I'm looking at 4 p.m., not because I cannot be here, but our staff, we have allowed our staff to basically have an event tonight, and thus I would like to, for their sake, I would like to close this meeting by the latest 4 p.m. with your indulgence. And any questions?
Madam Chair,
Yes, MP.
this is the second time that there's a function being held, and we were not invited.
MP Myers, I take note of your comments. However, I need to state that in the case of our staff, they are meeting to prepare for us because we were not, yes, part of their discussion is to decide what they're going to do to make up for the members of parliament and themselves. That's what's happening. So we will, thank you. Thank you. Yes, and thank you, MP Myers. But members, if we can do that, also given, again, I repeat what MP Myers indicated. So please pose whatever burning questions you have. We will then ask the minister if she can take these along, commit to us to have them provided in writing at her earliest convenience, and then we follow through with matters pertaining to justice. But at least we can get this long, dragging meeting closed off and deal with whatever matters in justice that might come up subsequently. So I was on the way to give the next speakers the floor, so I give the floor to MP Roseburg. MP Roseburg.
Thank you, Madam Chair. I will be very short. I do also want to make it known that I am happy that most of the questions were answered, and unfortunately, the questions were inherited, but you answered them through you, Madam Chair. And I would like to also make it known that I'm looking forward to the community safety project that I have initiated through Parliament, so that we can look into how the matters could be tackled. And just to look into one of the questions that my colleague MPs asked in regards to the landsrecherche and the role of the procureur-generaal. It's clear that in the law it's mentioned the procureur-generaal is the one that is the head, basically, and decides on matters in regards to the landsrecherche. So that comes from the landsverordening, of course, regelende organisatie, taken en bevoegdheden van de landsrecherche. That's all that I would like to bring forward now, and I look forward to the answers. Thank you, Madam Chair.
Thank you, MP Roseburg. I now continue, and I give the floor to MP Jansen-Webster.
Thank you, Madam Chair. Good afternoon to colleagues, and also good afternoon to the Minister and her support staff. I too will be brief. My questions are around the victim support services. I had the pleasure to attend a lecture last evening called Recognizing and Responding to Harassment and Abuse in the Community, which was hosted by civil society and which the director of Victim Support Services gave the lecture. Something interesting that came up there, and I was hoping that the Justice Minister could give it some attention, because I don't think it will burden the budget too much, which would be awareness of what Victim Support Services does, but also awareness of what, for instance, SEAEB does, what does Court of Guardian do, because people are not clear about what each entity does. The average person isn't clear about it, and if you could, make use of the newspaper that is the page in the newspaper that's already being paid for by government, just to get awareness out, also social media, etc., and so that people can know. Because I think you mentioned report to COG. I think it's at stmartingov.org, but what exactly can we report there versus what has to be reported to the police? That came up, so it would be good if people would know, because I myself, I was not aware that you can report directly to Court of Guardianship, and by having this email address, people can report anonymously, which with our culture, some people might want to do that more. And then also to look into having together with the other ministry, the Ministry of VSR, to look together with Ministry of Justice to have a joint helpline. And if we could train people, and it was discussed last evening, if we could train people who could answer the phones, that will help with our suicides numbers that are rising. We've seen them rising over the last 2 years, yes? So if we could get this kind of a joint help desk where volunteers or people getting a small stipend, seeing the budget, can man this helpline, and the helpline shouldn't cost also that much. I know that BTP is sometimes very willing to assist government with these kind of helplines. And then one other thing that came up yesterday again too was the privacy aspect of the police station. So when you go to the police station and let's say you're abused, you have to stand there and almost scream through the window and explain sometimes a very embarrassing situation for yourself of what happened, and that will deter victims. So if we could look at some kind of a kiosk when you come there that they can let you in and you can talk, because it's not private right now. Thank you. That's what I have for now.
Thank you, MP Jansen-Webster. I now give the floor to MP La Cruz.
Thank you, Madam Chair Lady. Madam Chair Lady, I just gestured to the Minister of Justice when my fellow colleague said it's only 2 months, that it's unacceptable. So she knows that she could do it. If my staff could come in and do it in 1 day, her staff could definitely do the same thing. But Madam Chair Lady, through you to the Honorable Minister of Justice, there's an article that I released and came out in the newspaper today. I don't know if you got the chance to see that article. And it relates to having a consul, they say in Spanish, embassy from other countries come to St. Martin, visit, and be able to renew passports and those documents that are extremely important for your ministry. This has nothing to do with any other ministry. The letter was addressed to the Prime Minister because he's the one that will be able to have a conversation via Buitenlandse Zaken, but this is directly for your ministry. And I have I know sometimes people write articles and, news media just for show, but I have a letter here before me with over 113 people that are right now in a very, very dangerous situation because their home country is at war. They cannot get passports renewed, and this means that they are now illegal on the island or have a problem because they cannot submit without having this document. Then I have 5 specific countries, which is one is Haiti, next one is Venezuela, people from Lebanon, Israel, and Palestine that are here that cannot find any ways or means to get those documents. So I know that and you were not the minister then, through you, Madam Chair Lady, but I did ask what are the possibilities and what could actually happen or how could we handle this situation, especially for people who have been here legally before. Let's just say if in 2019, I received a new passport. It is valid for 5 years. In 2024, it is expired. And that has been now the 5 years that I have been legal and the possibility of becoming a permanent resident now on St. Martin. I will end up with a gap, which means I will have to start all over again. It's niet eerlijk. So looking through de richtlijnen van de minister van Justitie met betrekking tot de landsverordening, toelating en uitzettingen, I did not see anything that had to do with that. I saw that on page 15, no, page 28, it speaks of consulata mogelijkheden. So I'd like the minister to look into that, see what could be done in that sense. Then in that same document, it speaks of, on page 15, we speak of voldoende financiële middelen. And it speaks of 2,000 guilders. And I know that a lot of people living here on St. Martin took the previous minister or the previous one before that one, Minister of Justice, to court and actually won because the minimum wage is set at a number lower than that. So I do believe that that policy or that ministeriële regeling should be adjusted in one way or the other. Then what I'd like to know from the 5 countries that I just mentioned, and when I thought about it, Madam Chair, Lady, through you to the Minister of Justice, this is not something that has to be done only for the Dutch side. It could be in collaboration with the French side, because there are a lot of people living on both sides of the island that, that literally have this same problem. So if the minister could let me know how much people do we have that live on St. Martin that do not have the Dutch nationality, so those that are putting in papers every year, every 2 years from these 5 countries, how much are waiting right now to be able to resubmit because they don't or they're missing documents. And maybe if there could be a system, because once I bring in a passport, or for example, a birth certificate with an apostille, me as a person, I don't change. So is there a way that we could legalize this document, put it somewhere in the system that the individual doesn't have the need to go back to his country and request that document again? That makes and feels like a burden in my eyes. Then I have another situation with the same thing that we have students now that are awaiting documents to even be able to submit for their Dutch nationality, to be able to request study financing. So this is extremely important. Thank you, Madam Chair, Lady.
Thank you, MP La Cruz. MP Otley.
Thank you, Madam Chair. Let me see if I can speed this up on double time. Honorable Minister of Justice, through you, Madam Chair. I heard your answer as it refers to the electronic monitoring. In 2013, there was a policy, and in 2015, there was an MR, number 21, that withdrew such policy or withdrew such legislation. So at this moment, to my knowledge, through you, Madam Chair, the minister is using discretion as to who is being released on ankle monitor. Is that so? And also, if it's not, would the minister be willing, if it is so, would the minister be willing to, within her term, very near future, reinstitute such policy that it is fair across the board and not based on discretion? I would like to know the minister's stance, your stance, especially since you're new, it's very important through you, Madam Chair, your stance on the minister being the boss of the prosecutor, the OM, but yet when the minister takes a decision that is not illegal, but against the advice of the prosecutor, the ability to form an investigation. What is the process when investigating your boss, the Minister of Justice, through you, Madam Chair? As it pertains to the OM, I just saw an article, for instance, where a case was dropped for Mr. Ted Richardson and George Willem. Now, this is heartbreaking because George Willem was not able to pass screening due to a case. And now today the case is dropped. And I was also a person that had to subdue to this. And if I did not fight, I would have not probably been the minister. So too often we are seeing this, and then it's just a, I'm sorry. What are the ramifications? Where do we go when the prosecutor messes up? Also, I am a proponent, and I'm asking these questions for a reason, because we're legislative. We are supposed to produce legislation. So I'm asking for a reason. What is your stance on adjusting the appeal process for prosecutors? I say this because no one brings themselves to court. The prosecutor decides to investigate, hold you, bring you to court. The judge, which is supposed to be the highest body in the judicial system, makes a decision, and the prosecutor is not in favor of that decision, so the prosecutor appeals. I do not believe that the prosecutor should have the right to appeal because you brought me to court. The right to appeal, this is my belief, should be solely with the lawyers, right? What is your stance on such? And it is legislation, and legislations can be changed, but I need your stance and your view. Also, through you, Madam Chair, I would like to know the minister's vision on the border control. I heard you touch on it. A lot of these answers, I don't know if you adjusted it through you, Madam Chair, or it was taken over from the previous minister, but your views on the border control, seeing that the French side, especially, persons can commit crime, go to the French side. When they get hold, if they are French national, the French does not really extradite you. They would handle the case over there. But I know that the Dutch side, we extradite in a heartbeat. So what is your vision? What is needed? And I ask this again, what is your views, legislation-wise, that would then, one, allow us to have some type of cohesion, or two, protect our citizens then, if that is the case. As well as I touched on it during the budget debate, I would like to know, since then, did you reach out to the unions pertaining to the partial payment to the justice workers? Very important. I don't want you to be faced with unrest. So if you have not, please do so urgently through you, Madam Chair. Also, I would like to know the minister's stance on persons being born here, obtaining residency. I see in the news Donald Trump tried to stop it, and a federal judge just rejected it. I would like to know the minister's stance on persons being born here of foreign parents receiving immediate residency. Also, the short-term, the plan for the minister to address the issue of L-bays with the prison. I heard you say that it is on your radar. I urge you to do so, because many prison guards are reaching out. I saw on your graph during the budget debate, 0 L-bays has been given out for the prison, while hundreds have been given out for justice workers. Please do not neglect the prison. Also, Minister, now that your budget is passed, there are also some short-term fixes that could be done. I urge you, if you have not, for you and your staff, through you, Madam Chair, to visit the prison. There are some small fixes that could be done, such as the church roof, uniforms, septic problems, as the septic is backing up into the kitchen area where food is being prepared, very unhygienic. Through you, Madam Chair, is there a process for persons? We have seen this process where the prosecutor puts off an appeal process for years, whereby a person is subject to appeal and the process is put off, but yet finally, after 1, 2, 3, 4 years, they finally have an appeal process and they are sentenced to 6 months. Now, had you bring me at the correct time, I would have been able to serve my time already. Now I have to wait 4 years, 3 years, just to serve 6 months. Is there something in the law that allows a reduction of time by the prosecutor extending the appeal process? Also, as it relates to the capacity of prison, through you, Madam Chair, is there something in the legislation or policy, or would it be prudent for a policy to be drafted where foreigners, persons of different nationalities, can be sent back to help create more capacity? I heard it was mentioned, but I would like to specifically know, is it somewhere in a policy, or would it be prudent of the minister in favor of such policy? And also, the minister, it was stated that we cannot ban a person once they are sent back. So if we can come to some sort of mutual agreement, if the prisoner then, legal-wise, if the prisoner then agrees to go back with them agreeing to not return, I think it's different than a ban. A ban is no agreement, it's one way. So I would like to know of such. And that'll be all for now, Honorable Minister of Justice. Through you, Madam Chair, I await your answers in writing.
Thank you, MP Otley. I now go over to MP Weever. MP Weever, you have the floor.
Thank you, Madam Chair. Good afternoon to the Minister, support staff, all those listening via whichever media. I will keep it very brief, seeing that my colleagues left me 2 minutes. I just want to also commend the Minister, because I've seen the increase within the controls on the various intersections as well, so congratulations with that. And just briefly, updates on the situation within the Simpson Bay Lagoon. I know the crime rate has increased there as well. Also following certain social media groups that are out there pertaining to the cruisers and the boaters. And you see the complaints within that, that sector. And that persons are still feeling that they're not really heard. There's still a lot of crime apparently taking place within that industry as well. And I know meetings have been done with different stakeholders as well. Is there follow-up? What's the situation there? Will there also be an increase and for safety for them as well? Because at the end of the day, they also bring a certain income to our country as well. Thank you, Madam Chair. That'll be all.
Thank you, MP Weever. Thank you, members of Parliament. Minister, you have heard the additional questions posed by the members of Parliament. I would want to propose that this meeting, we close this Central Committee meeting with the understanding that the Minister will provide answers to the questions posed in writing, based on which then, if necessary, specific topics in the answers can then be requested to have a meeting with the Minister on again. So, Minister, if I can just hear your response in terms of when you think, having heard the questions, that the members can look forward to your responses. Minister?
Yes, Honourable Chair Lady, I think within 2 weeks would be feasible. I would be able to answer them now, but I understand that we need to close. But if I may be permitted 1 minute just to address the matter of the lagoon, because I think that that's one that I should address immediately. Please. So indeed, MP Weever is correct that, despite our joint controls between the French and the Dutch side, we were having not the success that we had hoped within the lagoon, and that I think between about Christmas Eve up to the first week of January, there was still maybe 12 incidents in the lagoon, or at least reported, the majority of which on the French side. However, in the past week or week and a half, what I can report is that 3 perpetrators were caught on the French side, and since then we have seen that it has made an impact on the amount of incidents. And besides that, we have also received reinforcement to the Coast Guard. I actually swore in 4. I swore in 4 officers of the Coast Guard that came to assist the Coast Guard. They came from Aruba. So we have 4 additional members of the Coast Guard here to help alleviate the pressure that we were putting on the local Coast Guard organization. So that they are assisting both KPSM and the Coast Guard. They were sworn in, so now they also have police authority as well, besides, in addition to their authority as Coast Guard members. So that being said, we do think that now we have a more effective approach. We've looked at how we can broaden this, and of course, from the French side as well, I think the addition of them having a helicopter and for the other reasons that they had implemented one, we are seeing now at least that we're checking to see if this will now make a difference. But at least the apprehension of those individuals, which they had also been caught on the Dutch side and then again caught on the French side, so that has so far seemed to make a difference, and so this matter is being addressed, and I can update as I receive updates. So then I would like to say, I think 2 weeks then to go back is feasible for us to respond in writing to these questions. And then I would send those answers through the Secretariat.
Minister Taklin, thank you so very much for that indication and that clarification on the specific matter of the lagoon. Members of Parliament, I want to thank you for your collaboration and for your attendance at the meeting, and wishing all of you a good weekend and our staff a good evening together. And I hereby now close this Central Committee meeting of Parliament. Meeting closed.